Eric? Your mic,
What's that, what you need?
please. This evening's meeting will come to order. For those in the audience, there are agendas listing all the public hearings that will be here tonight on the table outside the double doors. We'll entertain consideration of minutes from the regular meeting of Planning and Zoning Commission on August 16th, 2018. Are there any additions or corrections to the minutes of the August 16th meeting? I entertain a motion to approve the minutes of August 16th of this meeting.
I move approval.
It has been approved by Mr. Pfaff.
And I'll second that.
It's been seconded by Mr. Waterbury. Please cast your vote.
With all members voting aye, the motion passes.
I would like to advise all the applicants that it takes 4 affirmative votes to carry any motion, not just a simple majority of those members present. Anything less than 4 votes is a denial. Applicants can postpone their public hearing until next month in anticipation of more Planning Commission members being present if they so desire. First, petition 18018RZ. Petition to vacate and replat Betty Luker Parkway Campus Number 2 and a portion of Elkhorn Valley Number 5, Lot 1 to create Elkhorn Village Addition, comprising 21.0 acres more or less in consideration of the request for rezoning of proposed Elkhorn Village Addition from PUD, Planned Unit Development, AG, Urban Agriculture, and R2 1-unit residential to entirely R2 1-unit residential. Said property is generally located northeast of the intersection of Newport and East 12th Streets. Applicant is Blackmore Homes, Inc. Do you have the staff report, please?
Thank you, Mr. Chairman. Staff's recommendation in this case is that if after the required public hearing, the Planning and Zoning Commission finds the requested replat meets the minimum requirements of the Casper Municipal Code, staff recommends that the Planning and Zoning Commission approve the replat and forward it to the Council with a due pass recommendation with the following list of recommended conditions. 1, on all double frontage lots along Newport Drive, East 12th Street, and Elkhorn Valley Drive or Gladstone, vehicular access shall be prohibited along said streets, and all vehicular access, curb cuts, driveways, and garages shall access internal streets only. 2, the plat shall be amended to dedicate the southern portion of Lot 53 in direct alignment with the planned future extension of East 12th Street as public right-of-way. 3, prior to the recording of the plat, the applicant shall obtain approval of all street names within the subdivision from the City of Casper Emergency Services Departments. And 4th, prior to the City Council review, the applicant shall obtain approval of a drainage study and a traffic study by the Engineering Department. With regard to the zone change, staff recommends that after the required public hearing, the Planning and Zoning Commission finds that the requested rezone of the proposed Elkhorn Village Addition to R2 1-unit residential meets the minimum requirements of the municipal code and is in conformance with the Casper Area Comprehensive Land Use Plan. Staff recommends that the Planning and Zoning Commission approve the zone change and forward a due pass recommendation to the City Council. Regarding code compliance, staff has complied with all requirements of Section 1624 and Section 1712-170 of the Municipal Code pertaining to replats and zone changes, including notification of the property owners within 300 feet, posting of the property, and publishing legal notice in the Star Tribune. Staff received 2 letters of concern regarding this development. In summary, Blackmore Homes, Inc. is the applicant for the requested replat and zone change for the proposed Elkhorn Village Addition. The property encompasses 21 acres, more or less, and is located directly north of the intersection of East 12th Street and Elkhorn Valley Drive. The subject property currently consists of multiple parcels with multiple zoning classifications. A zone change to R2, as requested, is proposed to consolidate the zoning of the new subdivision. Staff has included several recommended conditions of approval in conjunction with the replat. As has been the case with other subdivisions that have been proposed with double frontage lots, it's necessary to restrict vehicular access to only one of the streets. All vehicular access, curb cuts, driveways, and garages should be accessed via internal local streets only, and no access will be permitted off the higher volume collectors, Newport Drive, East 12th Street, and Elkhorn Valley Drive. In order to accommodate future growth to the east, staff has requested that the southern portion of Lot 53, which aligns with East 12th Street, be dedicated as right-of-way. This request is supported by the Major Streets Plan, which is found on page 4-12 in the Generation Casper Comprehensive Land Use Plan, which illustrates that East 12th Street will be extended as a minor arterial street east from its current terminus at some point in the future. The dedication was requested of the applicant, and the applicant stated they don't wish to provide the necessary right-of-way. Engineering has requested a traffic study for the project, which has not yet been initiated. A drainage study has been provided, but has not yet been approved by engineering. The Planning and Zoning Commission can forward the proposal to City Council with a condition that those studies be completed and approved prior to council review, or in the alternative, the Planning Commission may wish to consider tabling the proposal until they're complete. Section 1712-170 of the Municipal Code requires that staff review all zone change requests in context with the Comprehensive Land Use Plan, and staff is required to provide a recommendation of the Planning and Zoning Commission and City Council as to how the zone change is either supported or not supported. As was the case with the 2000 Comprehensive Land Use Plan, the Generation Casper Comprehensive Plan provides a future land use plan, which is found in Chapter 4 on page 4-26. The future land use plan is an illustrative plan that identifies the physical distribution of land uses and forms the basis for future zoning and land use regulations. The property in question is in an area that is designated as Neighborhood 2 by the FLU. The plan indicates that the development areas designated as Neighborhood 2 are characterized as built on traditional development patterns, served by highly connected street patterns, and interspersed with schools, public facilities, walkable neighborhood amenities, parks, and trails. This designation is prevalent throughout much of Casper, and the primary types of land uses associated with Neighborhood 2 designations are conventional, detached single-family units, twin homes, and multifamily up to 10 dwelling units per acre. The proposed R2 zoning district allows as permitted use any and all of the 9 uses found in your staff report, and I won't go ahead and list those individually. Mr. Chairman, there's 9 exhibits I'd like to enter. A is the replat application. B, vicinity map of the 300-foot notification zone. C, copy of the plat. D, petition for zone change. E, legal notice sent to the Star Tribune. F, notice of public hearing sent to property owners within 300 feet. G, public comment from George and June Hartman, 1220 Elkhorn Valley Drive. H, public comment from Ken Carpenter, 1836 Willow Creek Road. And I, memo to chairman and members of the Planning and Zoning Commission. That concludes staff's report on this item, and we'd be happy to answer any questions.
Does anybody on the committee staff have any questions?
Mr. Chairman,
Commissioner?
Craig, I do have one question on your recommendation, recommended condition number 4. It reads to us as prior city council review, the applicant shall obtain approval of a drainage study and traffic study by the engineering department. Is that intended to mean that those studies would be completed before city council reviews, or that they just be in the mill and approved to be done?
That was my intention with the wording, yes, that those would be submitted and complete and approved before council gets to review the project, in case any changes are necessary with the plat.
Okay, thank you. That's all I had, Mr. Chairman.
Any other? Seeing none. Yes, ma'am?
Mr. Chairman, may I ask a question? You talked about the vehicular access to these, and you indicated that everything should be via internal and local streets, yet there's one lot that sits on 12th Street that doesn't look like it has any internal.
Lot 34.
Pardon?
Lot 34, I think you're referring to.
Yes.
Yeah, the way that it was worded, it was lots with double frontage, and
Okay.
since that doesn't have double frontage, that would not.
That's kind of what I
Affect that.
thought you meant. Okay.
One further comment from myself here, if I could have a question, please. The roads in question were listed as the Newport and 12th Street, but what about Elkhorn Valley Drive as far as the lots for internal?
Mr. Chairman, good catch. The staff recommendation lists all three of those, and if you look at the dedication on the plat, it only lists two of those streets. So that would be, I think the condition that staff wrote would cover it. They would need to change the plat to abide by that condition if the planning commission chose to adhere to that staff recommendation.
I think some of the other questions can probably be addressed by the applicant. So I'm going to ask them the same question. Are there any other questions from the commission for staff? I now declare the public hearing open for consideration of case PLN 18018RZ. The hearing will be conducted in accordance with state statutes and rules of the Planning and Zoning Commission and other applicable laws. I would ask those individuals who address the commission to approach the lectern, identify yourself and state your address. Would the person representing this case come forward and explain the application?
Good evening. Good evening. My name is Brandon Daigle. I'm with River Valley Builders here on behalf of Blackmore Homes. We're proposing this development as a continuation of the extension of Elkhorn Valley Drive as outlined. Specifically, we are comfortable with the limitation to access on the internal streets on the double-loaded lots. I also did want to clarify the comment about not being willing to dedicate the portion of Lot 53. After review with staff, we have further reviewed internally and decided that we will replat it to include that dedication for the 12th Street extension as part of it.
Okay. Is there anything else?
I'd entertain.
Are there any questions from commission?
Brandon, am I correct that you have reviewed the four conditions that staff is recommending, and you don't have any concerns to speak of with the way they're presented to us?
No, we're comfortable with those. We're comfortable with the plans and the design requirements prior to proceeding with council.
Thanks.
Brendan, I have a question. I've noticed on here that there's several instances, and the dedication was a little vague, that there's tracks, some of them are larger than others for signage and for drainage and walking traffic or something like, who's going to own these?
So Blackmore Homes will retain those as ownership, and part of the design aesthetic is to have those as gateways, so more so than just a cornerstone sign, but something you might see in a development in Metro Denver where they have some sort of signage and landscaping. We're setting up the structure of the maintenance agreement with the property owners within this, whether it's a dedicated HOA or some other form of recapture fees. I will say that our budget to date includes actual sod and paved sidewalks through the pathways as opposed to what's been previously developed in the Black Vista Ridge 4, whatever that development is. So the intention is that it's an upper scale development. We would equate it to something like Rustic Ridge, which was done years ago, but to have that kind of enclave aesthetic to it.
Thank you. And about the changes in the plat that you're going to make on the track 53 dedicated for the continuation of 12, as far as that drive is going to, will that be added to the other two streets by the limitations?
I'm sorry, I missed the question.
The Elkhorn Valley, there are lots on here that go on both sides.
Yeah, so we
And
would have.
so this was not mentioned in the dedication.
Correct. We would have the front only access on.
Okay.
Except, okay, so just to be clear, the ones on the east half of the extension of Elkhorn Valley Drive, that is their front access. The back loading is separate property owners, so those ones will be accessed from the front. The intention of the ones on the west side of Elkhorn Valley, with the exception of that corner lot, would be that they would be accessed from that interior cul-de-sac area
Okay.
on the west of those lots.
Thank you. Any other questions?
I do have a question. Were you able to access or look at the comments that were submitted to us?
I briefly reviewed those yesterday, yes.
And was, one of them had asked whether or not, are you going to put a fence around the development, or?
So there will be fences along the backs of those lots. To what degree the aesthetic, we would have a consistent aesthetic of those fences, but there is no plan currently to build the precast concrete walls that are along the west edge of Newport at this
So
time.
they may be more like what you'll see in most neighborhoods that the owner puts up on their own.
Yes, but they would have to follow a design criteria, so they would have to be some sort of vinyl fence and a
Okay.
neutral gray color to match everything else.
Okay, and it will,
be consistent.
okay, so, and your intention at this time is that there'll be the height that was requested at 6 feet?
Yes.
Okay. Thank you.
Thank you. Any other questions?
Thank you all.
As required by state law, we have to invite people to comment in favor of or in opposition to all public hearings. Is there anyone in the audience wishing to speak in favor of case PLN 18-018RZ?
Good evening, Mr. Chairman, members of the Planning and Zoning Commission. I'm Michael Reed. I reside at 1615 Luker Drive, which is just to the south of this proposed development. I'm also the president of the Homeowners Association for the Elkhorn Valley 2 area, which includes Miracle Luker, Elkhorn Valley Drive, and 21st and 22nd Street. We did discuss this at our Homeowners Association meeting last month. We kind of went over what the plan was going to be, and it got approval from the Homeowners Association. We thought it'd be really good for the area. It will complement the homes that are there now, and protect the environment of that area, which is really great. It's a real quiet area, so we certainly would speak in favor of it.
Are there any questions? Thank you.
Thank you.
Is there anyone any further in favor?
My name is George Hartman, and I live at 1220 Elkhorn Valley Drive. And I was the one that wrote the comments about the barrier along the 12th Street. And I'm confused, are we going to have a barrier or not there? Have we decided that?
Unless I did not hear correctly, I'm thinking there's going to be a fence put up by the homeowners, and it will have to meet a certain set of guidelines, but it will not be a stone fence like you have on the other side of the street. Is that, if you let the record show that I got an appropriate.
I guess I would ask, why not? You have it on some of the areas, why can't we have it on that area? But
I don't know that unless Mr. Daigle would like to.
Do we approach it, or do we just not have it open forum?
Please approach. We don't want to get that.
So at this point in time, sir, this is extremely preliminary, and our cost estimates at this time don't allow for that long of a fence and that price point. If we get further into it, we can realize the cost and the scale and the cost, then we would entertain a more suitable fence. But the cost of that fence of the previous one makes this project, if we were to do the entire perimeter, it would be cost prohibitive. So at this time, we don't have it in our budget to accommodate that.
I guess I'm not asking for the entire perimeter, just next to my house.
Understood.
I'll stay on 12th Street too. I mean, on Newport.
You guys like to
Thank you. Is there anyone in the audience wishing to speak in opposition to this case? Seeing none. There being no others to speak for or against this case, declare the public hearing closed and advise that the replat and zone change will be voted on separately. I will entertain a motion to approve and forward to council with a due pass recommendation, nigh or table, regarding the zoning application.
Mr. Chairman, can we get the plat first? That way we can reference the plat when we do the zoning.
Although, okay, it was, I thought,
Thanks, sorry about that.
regarding the replat.
Mr. Chairman, on PLN 18018 RZ, that's a rezone. I would recommend that we approve the replat with the 4 conditions that are listed in the staff report.
And we had some additional, I guess we can,
We would need a second before we discuss,
okay,
Mr. Chairman.
we have a second?
That was in the form of a motion. You said recommend. But are you-
Well, recommend, yes, okay, it is in the form of a motion. I would move to recommend to city council that we replat this, including the 4 conditions in the staff report.
I'll second that.
Discussion.
Mr. Chairman, I'm
Mr. Ryan.
wondering if we should add a 5th condition requiring a fence along Newport.
Say that again?
I'm wondering if we should add a 5th condition requiring a fence along Newport. Because right now it's being left open to an HOA, it sounds like, to enforce it upon the purchasers of those lots.
Any comments? Well,
Mr. Chairman and Commissioner Waterbury, are you moving to amend this, or are you just looking for discussion?
I was looking for discussion.
So you would want that fence along Newport, but not along 12? Isn't the plan to ask all the landowners to build the fence so it would be all the way around? Thank you.
Mr. Chairman, if I could, I'm a little bit uncomfortable with mandating a 5th condition relating to the fencing. I think that from what I've seen and heard, I think it's going to be developed in a prudent manner, and that issue would more than likely go away once the area is developed. I mean, I just have that feeling, so I would not be supportive of adding a 5th condition.
any other discussion? Would it be prudent to have a vote on that particular?
Mr. Chairman, there's been no motion made to bring that before the floor for a vote, so right now what's on the table is the 4 conditions that have
Okay,
been recommended in staff's report.
Commissioner Waterbury, do you have anything further to say? Well, we have a discussion, we have a motion and a second.
Mr. Chairman, are we including the studies for the drainage and traffic?
Yes, that's one of the, shall
That's one of the 4 conditions.
obtain approval of the drainage study and the, yes, that's in traffic. They will have to be done before the plat is approved.
Got it.
Mr. Chairman,
Yes.
I call for the question.
Time to vote.
Time to vote. Okay. Will you vote? Record the vote.
With all members voting aye, with the exception of Commissioner Waterbury, the motion passes.
I'll entertain a motion to approve and forward to council with a due pass recommendation, deny or table case PLN 18-018R regarding the zoning.
Mr. Chairman, I would move to forward a due pass recommendation as presented to the City Council for PLN 18-018RZ zoning.
Do I have a second?
Mr. Chairman, I'll second that.
Thank you, Ms. Frank. Commissioner? Discussion? Being no discussion, please cast your vote.
With all members voting aye, the motion passes.
Motion is carried. Again, I would like to advise applicants on PLN 18019 ARZ, the next petition. It takes 4 affirmative votes to carry any motion, not a simple majority in those members present. Anything less than 4 is a denial. Applicants can postpone their public hearing till next month in anticipation of more commission members being present if they so desire. 18019 ARZ, petition to annex the plat portion to south half northwest of section 9, Township 33 North Range, 79 West, the 6th Prime Meridian, Natrona County, Wyoming, and a vacation and replat of Lot 2, Block 1 and Lot 1, Block 2, Bailey Addition, Number 2, Lot 1 of Stovall Brothers Addition to create State Office Building Addition, comprising 11.06 acres more or less, located at 44-4 West Collins Drive, and consideration of a request to establish the zoning of the subdivision as city zoning classification OID SPC, Old Yellowstone District and South Poplar Corridor. Applicant is the State of Wyoming, Department of Administration and Information. Staff report, please.
Thank you, Mr. Chairman. Staff's recommendation on the annexation is that after the required public hearing, the Planning and Zoning Commission finds that the requested annexation meets the requirements of the municipal code. Staff recommends the Planning and Zoning Commission approve the request to annex the subject property and forward a due pass recommendation to City Council with the 5 reasons listed in the staff report. Regarding the plat, if after the required public hearing, the Planning and Zoning Commission finds the requested plat meets the minimum requirements of the Casper Municipal Code, staff recommends that the Planning and Zoning Commission approve the requested plat to create the State Office Building Addition and forward a due pass recommendation to City Council. Just want to note that staff has not provided any recommended conditions. However, if the Planning Commission decided that conditions were necessary, those could be added on the fly. And regarding the zoning, if after the required public hearing, the Planning and Zoning Commission finds that the requested zoning of the State Office Building Addition to OID SPC meets the minimum requirements of the municipal code and is in conformance with the Generation Casper Comprehensive Land Use Plan, staff recommends the Planning and Zoning Commission approve the rezoning and forward to the City Council with a due pass recommendation. Regarding code compliance, staff has complied with all requirements of Section 1624, 1636, and 1712-170 of the Casper Municipal Code pertaining to annexations, plats, and zone changes, including notification of the property owners within 300 feet by first-class mail, posting of the property, and publishing legal notice in the Star Tribune. Staff did not receive any public comments on this case. In summary, the state of Wyoming is preparing for the construction of a new state office building to be located on 11 acres, more or less, generally located north of the Natrona County High School along the north side of Collins Drive. The property consists of multiple parcels, some of which are developed and some of which are unplatted and unannexed and vacant. The state plans to demolish all the existing buildings this fall and is preparing the site to begin construction of a $40 million campus, which will house various state agencies that are presently spread around the community. The state is in the process of developing a site plan for the project, which will be reviewed and approved by the OID Architectural Review Committee. The proposed zoning of the property is in keeping with the zoning of the surrounding properties, as well as the OID District Redevelopment Plan and the Generation Casper Comprehensive Land Use Plan. Mr. Chairman, I have 8 exhibits. A is the application for annexation. B, application for replat. C, petition for zone change. D, vicinity map of the 300-foot notification zone. E, copy of the plat. F, public notice sent to the Star Tribune. G, notice of public hearing sent to property owners within 300 feet. And H, memo to the chairman and members of the Planning and Zoning Commission. That concludes staff's report, and we'll be happy to answer any questions.
Are there any questions for Mr. Collins?
I have a question.
Commissioner Frank?
So we're actually doing 3 things with this. First, we've got to annex it,
Part of it.
just the part.
The part that was former railroad right-of-way was
Oh, I see, okay, thank you. And then the plat, and then the zoning.
correct.
Thank you.
Is there any other questions of staff? I now declare the public hearing open for consideration of case number PLN 18019 ARZ. Hearing will be conducted in accordance with state statutes, the rules of Planning and Zoning Commission, and other applicable laws. I would ask those individuals who address the commission to approach the lectern and identify yourself and state your address. Would the person representing this case come forward and explain the application?
Mr. Chairman, my name is Jim Chappett, live at 7950 Hat Six Road, work for the state of Wyoming State Construction Department. I didn't hear your question, I apologize, fairly deaf.
Or I wasn't speaking into the microphone. Okay.
Love your mic.
My question was, you're the person representing this case. Would you like to explain what's going on?
Mr. Chairman, the state of Wyoming has 8 agencies that are scattered around the city of Casper. I think all of them are in lease space at this time. The state would like to consolidate all of those agencies into a one-stop location. Felt that this was a great place to do it. The 8 agencies, a lot of them have the same customers that frequent them. This will put it all on a bus route, make it easy for people to transport to and from the facilities that the state agencies that they need. A lot of them use several of the same agencies at the same time, so it's a matter of economics for both the state and the people and the taxpayers, the folks that use the services.
Thank you. Are there any questions for Mr. Chapman? Thank you very much, sir. As required by state law, we have to invite people to comment in favor or in opposition to all public hearings. Is there anyone in the audience wishing to speak in favor of this case?
Mr. Chairman and Planning and Zoning Commission, my name is Jim Canellis with the Office Bar and Grill, right next door to this wonderful building that I can't wait to have next to me. I've been there for quite some time, since 2003, and I've been next to empty lots and quite often empty buildings on the other side. I just have a couple of things I just want to plant out there is, one, because that is railroad land behind me, it retains water quite well. It doesn't dissipate, and I'd like them to really consider at the time when they work on this and the landscaping I've seen in past examples of what's going to be there, that the irrigation would be beneficial to everyone. And the other thing that I'm kind of concerned about, and I just want to make sure that whoever speaks or comes to talk to me or how this works is, of course, I'll be next door on two sides, and my parking, of course, I'd hate to see somebody run right over onto their grass. So I wonder how that landscaping is going to be come that time, and to make sure that I can do whatever that needs to be done to make sure this is never going to be an issue as well. Other than that, I'm looking forward to it, and that's just all I had to say, and I'll leave this right up here. Any questions for me?
Thank you. There was a question that was asked. Would you like to address that, Mr. Chairman?
Mr. Chairman, Jim Chappett. Yes, we have discussed the drainage issue that the office bar has, and they've experienced it for a few years. I've even seen it in the newspaper. We've discussed it with our civil engineer. We're well aware of that problem. As far as the landscaping plan, it's still in the process, but we'll certainly take Mr. Calano's suggestion into the planning meetings.
Thank you very much for your statement. Is there any further? Is there anyone in the audience wishing to speak in opposition to this case? Seeing none, I now declare the public hearing closed and advise that the annexation, replat, and zone change will be voted on separately. I will entertain a motion to approve and forward a due pass recommendation to City Council to deny or table the case number PLN 18019 ARZ regarding the annexation.
Mr. Chairman, I move in regards to case PLN 18019 ARZ, specifically with regard to the annexation, that we pass forward a due pass recommendation to City Council for the 5 reasons listed in our staff report.
I have a second.
Mr. Chairman, I'll second that.
Thank you, Commissioner Frank. Any discussion? Please cast your vote.
With all members voting aye, the motion passes.
I'll entertain a motion to approve and forward a due pass recommendation to City Council, deny or table this case regarding the plat.
Mr. Chairman, I would move for approval to recommend City Council replat of the land specified in PLN 18019 ARZ.
And I'll second that.
Any discussion? Please cast your vote.
With all members voting aye, the motion passes.
I'll entertain a motion to approve or forward a due pass recommendation to City Council, deny or table the case regarding the zoning.
Mr. Chairman, in regards to case PLN 18019 ARZ specifically for the zoning, I move that we pass a do pass recommendation to City Council.
Do I have a second?
Mr. Chairman, let Fred.
With the bill. We have first and second in the discussion. Please cast your vote.
I do have just a
Yes, sir.
quick comment, just since we're here. I think, my comment is, I think if you folks sense that, I think the community in general is optimistic and anxious to see this project move ahead, and we're looking forward to seeing it move ahead expeditiously. And from the drawings that I've seen, I think it's going to be an exciting addition to this part of town for Casper, so appreciate it. That's all I have.
Please cast your vote.
With all members voting aye, the motion passes.
Thank you very much. Again, I would like to advise applicants, it takes 4 affirmative votes to carry any motion, not a simple majority. Less than 4 is a denial. Applicants can postpone public hearing until next month in anticipation of more members being present if they so desire. PLN 18020-E, petition for an exception on a variance to allow additional 120.55 square feet of signage in excess of current 600 square foot signage limit in C2 General Business Zoning District. Located on Clausen, Art replat 4 and 6, Lot 5 Commercial, located on 600 West F Street. Applicant, McDonald's Real Estate Company. Staff report, please.
Thank you, Mr. Chairman. Staff's recommendation in this case is that absent information that may be presented during testimony, staff recommends that the Commission deny the exception or variance request based on the following finding. Under the circumstances presented, strict compliance with Title 17 of the Zoning Code would not create an undue hardship upon the applicant because there are no unique physical limitations or characteristics of the property that deny the applicant the reasonable use of the property and which do not apply generally to all other land or buildings in the immediate neighborhood. Regarding code compliance, staff has complied with all requirements of Section 1712-220 pertaining to exceptions and variances, including notification of the property owners within 300 feet by first-class mail, posting of the property, and publishing legal notice in the Star Tribune. Staff has received some public comments, and I apologize, the staff report doesn't reference those, but those have all been provided to the Planning Commission and will be referenced in our exhibits at the end. Section 1712-220F presents the conditions in which the Commission may grant an exception and states that the Commission may vary or adjust the strict application of any requirement of the zoning ordinance involving any physical restriction applying to a lot or building if the strict application would deprive the owner of the reasonable use of the land or building involved. No adjustment in the strict application of any provision of the zoning code may be granted unless A, there are special circumstances or conditions fully described in the Commission's findings which are peculiar to the land or building for which the adjustment is sought and which do not apply generally to the land or buildings in the neighborhood and which have not resulted from the action of the applicant subsequent to the adoption of the ordinance. B, for reasons fully set forth in the Commission's findings, the circumstances or conditions are such that the strict application of the provisions of this ordinance would deprive the applicant of the reasonable use of the land or building. The granting of the adjustment is necessary for the reasonable use thereof, and the adjustment as granted is the minimum adjustment possible to allow the owner the reasonable use of the land or building involved. And C, the granting of the adjustment is consistent with the general purpose and intent of this title and will not be injurious to the neighborhood or detrimental to the public health or welfare. Section 1712-220G8 outlines the 4 findings the commission must make in the granting of an exception. It states that the commission can only grant exceptions if they articulate the reasons for all findings, and there's 4 of those. 1 is the exception will not substantially impair the land use of the neighborhood or adversely affect the safety of the adjacent property. 2, the exception will not conflict with the comprehensive land use plan as adopted by the commission and confirmed by the council, nor violate the purpose or intent of the ordinance. 3rd, under the particular circumstances presented as set forth in the findings of the commission, strict compliance with the terms of the ordinance will cause undue hardship upon the applicant. And 4th, the applicant or predecessors in interest have not, by affirmative act or acts, caused a condition or use to exist in violation of the terms of the ordinance for which the exception is requested. In summary, McDonald's Real Estate Company is asking for an exception to allow additional signage in excess of the 600 square foot maximum sign area allowed in a C2 zoning district. The property is located at 600 West F Street and is fully developed as a McDonald's fast food restaurant. McDonald's currently has 420 square feet of signage on the site, more or less. In addition to McDonald's on-premise signage, the Planning and Zoning Commission approved a conditional use permit in 2009 to allow an off-premise sign or a billboard on the property up to a maximum permitted size of 32 square feet. Therefore, the site contains approximately 452 square feet of signage, which is less than the 600 square foot permitted. The applicant and the owner of the off-premise sign are involved in ongoing litigation over the signage on this site. As such, the Planning and Zoning Commission may decide that the timing of this case is not ripe, so it can be delayed until litigation is complete if the Planning Commission decides. The Planning and Zoning Commission rarely sees exceptions or variance requests because of the strict legal findings required for approval, particularly the finding of an undue hardship. An undue hardship is shown when the proposed land use or use of the land for a permitted purpose is so impractical that the lawful use of land will be destroyed unless an exception or variance is granted. In this regard, undue hardship exists only if the problem is unique to the property of the applicant and is not shared by other landowners in the district. The granting of an exception or variance should only be used to relieve a property owner of following a land use law when following it would deprive the property owner of all reasonable use of their property based solely on a unique physical characteristic or limitation associated with the property. There is no undue hardship in this case that warrants the approval of an exception. The applicant has full use of their property, and no physical characteristic of the land would deprive them of the reasonable use. The applicant is afforded the same amount of signage as all the other similarly zoned and located businesses enjoy. When any property owner in the district allows an off-premise sign to locate on their property, the size of the off-premise sign counts towards the total amount of signage allowed on the site. To treat off-premise signage as a burden to the property owner is unfounded. Allowing off-premise signage to be considered a burden and used as justification for granting of an exception or variance could encourage a proliferation of these types of requests in the future. Mr. Chairman, we have 7 exhibits. A is the application for a petition for an exception. B, vicinity map of the 300-foot notification zone. C, legal notice sent to the Star Tribune. D, notice of public hearing sent to property owners within 300 feet. E, materials submitted by Judy Studer on behalf of McDonald Real Estate Company received August 9th, 2018. F, materials provided by Ryan Ford on behalf of Casco LLC received September 13th, 2018. And G, memo to the chairman and members of the Planning and Zoning Commission. That concludes staff's report.
Thank you. Thank you, Mr. Collins. Any questions for Mr. Collins or any other staff members? I have one before I open the public hearing. Wallace, may I address this to you? This particular case, after reading through as much as I could, has been decided and it's been appealed and it's still under judicial review. How much leeway, if any, do we have? And anything we do could be overturned.
Mr. Chairman, there are a couple of different responses to that. The first would be that I'm going to let Ms. Studer speak to the litigation that's ongoing. But what's in front of you is the land use decision to be made, not the litigation decision to be made. How much leeway you have under case law, if you have a rational basis for your decision, it will probably be upheld. My position on the legal status of the land use aspects of this case is very clear in staff's report. I helped them put that together. Ms. Studer is going to present a different view of how the ordinance is read that I don't share. But if you think it's rational, there are 3 options that you would probably have. The first is to follow the recommendation of staff report. The second would be to continue the case. And the third would be to consider what the applicants are presenting and see if you find it reasonable or not. In that case, you would have the ability to follow a different recommendation and a different way to handle the problem. And I'll address more comments after you've had a chance to hear what all the sides have said about it.
Thank you. I now declare the public hearing open in accordance in consideration of case PLN 18020E. The hearing will be conducted in accordance with state statutes, the rules of the Planning and Zoning Commission, and other applicable laws. I would ask those individuals who address the commission to approach the lectern, identify yourself, and state your address. Would the person representing case PLN 1802 exception come forward and explain the application, please?
Thank you. Good evening. My name is Judy Studer, and I represent McDonald's Real Estate Corporation. And I'm the person that filed the petition on their behalf. And I have to say, I think this is going to be a very unique hearing in that you're never going to be presented with this set of conditions again. And I would submit to you that that is what makes this unique and ripe for your consideration to grant this exception. So, before I tell you where Wallace and I disagree on the legal analysis, and remember, that's why we have a Supreme Court, 5 people, and they don't always agree because there's always different legal analysis that can be applied. But let's just talk facts. Initially, McDonald's Real Estate Corporation purchased this property. You know, there was this small signage easement. I don't know, in your packet, it would be under Exhibit E. I think it's number 2. If you look at that, you're going to see these very tiny 2 signage easements under off-site premises. They can only have 1 sign. Okay, so that's what we're dealing with. Now, easements, normally you can build on those easements. You can do whatever you want. It doesn't restrict your own abilities because they get the easement, but you still have use of your property. In the unusual circumstance of this case, we had a federal judge say, I disagree with that general law. What, in fact, I've ordered now is that even though this lot is assigned 600 square feet, I am going to give an exclusive easement to these 2 little parcels, 300 square feet, or 300 square feet of signage. So 50% or 300 square feet. So it's basically gave them an exclusive easement that McDonald's can't touch. And as a result, they now are restricted to 300 square feet. The problem is, as you heard, this planning commission, the planning department approved 420 square feet. So now, while we technically are in compliance with city code, we are in contempt of court. And that's a big deal because what happened is McDonald's obviously respectfully disagrees with the judge's decision. This is ridiculous. They're not using it. They're only using 32 square feet. We're well within our rights. Why can't we just leave it as is until the appeals court decides this matter once and for all? Well, that didn't happen. Instead, what we're faced with is a motion to show cause why we should not be held in contempt. And what that means right now is we have to tear down the signs that exist. The highway sign that brings in money to this community has to come down tomorrow unless you're willing to grant us some relief. Okay, so that's the circumstances. Now, once and for all, what's going to happen is the appeals court will decide if we're right or if they're going to uphold the federal judge's decision. And once that's decided, then obviously when I submitted this application, I did not know staff's recommendation. In fact, I had gotten a lot of positive feedback from the city manager in my conversations. But then I saw staff's recommendation, and it's like, whoa, what can we do? This discussion turned around, well, let's talk maybe conditions. And then the concept of, and Wallace suggested this, although he does not endorse this, I want to make that clear, but giving us a temporary exception, which will allow us then to do nothing. But that way we don't have to tear down the sign starting tomorrow to be in compliance with the court order that if we're successful, we can put the sign back up. And so that's the hardship. This is ridiculous, to have to spend all this money to tear down something that may be fine to begin with, but that's the circumstances we're facing. So let me now tell you why legally I believe that you have the authority to do this. First of all, I have to point out that with respect to the municipal code, there's a difference between the definition of an exception and the definition of a variance. A variance is specific because it requires a physical issue with the lot, and that would be a necessary hardship because the property is irregular, narrow, shallow, steep, physical conditions. But look at the definition of exception. It's not tied to the physical conditions of the property. All we have to show is a unique characteristic, okay? And that is what we've now applied for, is an exception/variance. You have the authority to modify the request, and that's why I want to say now what we're actually asking for is a temporary variance, and would ask that you consider that. Now, under your authority, let me go through exactly what staff, based on Mr. Trembaz's analysis, is that there, you're looking at subsection F of City Code, I want to make sure I get it right, 220? Okay, thank you. All right. But that's if you read the first 3 lines or 3 words, the commission may vary. Remember, variance. If you look under G, the commission shall have the authority to grant exceptions. There's a distinction. F applies to variances, G applies to exceptions. Sorry. But to be even more specific, because in the law, specific applies over general. And so specifically, if you go to the sign ordinances in the municipal code, in section 17.96.100E, exception procedure. And it states that, reading through some of it, to grant an exception from the strict application of this chapter where such strict application will result in practical difficulties or unnecessary hardship to the person owning or having beneficial use of the property or sign for which an exception is sought. So let me emphasize, will result in practical difficulties to the person owning the property. That's what we're talking here. You have specific authority under the special sign ordinances that would allow you to grant the relief that we are seeking. And I want to be very clear. We're not seeking to construct anything. We just need a temporary reprieve so we don't have to tear down the signs in order to let the appellate court decide once and for all what's going to happen with the signage on this property. So that's the most specific code section I can find. Let me go back now to section 220 that was quoted to you at length. If you look at, again, section G, specifically number 7 again, we get back to the signage. This board has authority to grant an exception from the strict compliance with sections, goes through it, that will result in undue hardship being imposed upon the person owning or having the beneficial use of the property or sign for which the exception is sought. And then Mr. Collins did go through those 4 analyses. And I think staff is supportive that we meet those 4 analyses. The focus that you heard from staff is, well, there's not a physical problem with the property. That's the hang-up, or I believe the disagreement that we have between us. But let me talk about the specific 4 requirements under paragraph 8. In the code, they're listed A, B, C, D. Tonight, I think they're described as 1, 2, 3, 4. The exception will not substantially impair the land use. No, we're not building anything. We're not impairing anything. B, or 2, it doesn't conflict with the comprehensive land use plan. This comports with the comprehensive land use plan. It's already been approved, the existing signage by the City of Casper Planning Board Commission. And then C, under the particular circumstances presented, strict compliance with the terms of the title will cause undue hardship upon the applicant. The strict compliance in this situation is by limiting us to 600 square feet. We have to tear down our sign even though we're at 420. Thus the reason for our request to please give us an exception for 120 square feet that we're not going to use. But if you do that, we don't have to change our signs until we get a final decision. And that is why I would ask each of you to just consider that that is a unique circumstance that this board, this commission is never going to hear again. And then finally, that the applicant did not create the situation by any affirmative act. And that's where I talked about initially. This property was purchased with the idea that, yeah, there's an easement, but it's not an exclusive easement. As long as they have 32 square feet, we can have our 420 square feet. We can be compatible. It's not until a federal judge changed the circumstances and said, no, don't care that they're not using it, you have to restrict yourself to 300. Thus, our request to say, please give us that extra 120, make it temporary. We can live with that condition. Just give us time to get a final answer. And again, as I mentioned, I was in communication with staff. I mean, they have been very communicative and, helpful. I was well aware of Mr. Trempath's analysis, but did develop conditions for this situation. And let me just, for the record, and this is stuff that's going to probably bore the commission to tears, but I just needed to want to put in a couple of cases where a similar situation arose, and that would have been 289 A. 2nd, 881, Nathanson versus District of Columbia Board of Zoning. In that case, what it was is an exception for construction of a storage facility in a residential area, nothing to do with the physical condition of the property. There basically was whether or not the condition that they had to build a little cement 4-foot wall was upheld by the commission. The other case I had cited previously in my submission to you was a case, it has Philadelphia in the name. It's part of the packet or exhibits that have been submitted. In that case, they were changing an industrial building into multi-family housing. And again, it had nothing to do with the physical characteristics. It was because of the unique circumstances presented. So with all due respect, lawyers can have a different analysis of what these regulations mean. I think this is well within your rights. I also think it would be helpful to a local citizen to get this reprieve, basically, for a temporary period of time of 2 years. With that in mind, as I said, with the help of Mr. Trempath and Mr. Collins, drafted up a recommendation which makes it temporary so that you know that you're not going to, or that McDonald's is not going to violate the municipal code, that this thing will expire by its own terms, but it will give us the time that we need to get this resolved, that the 420 square feet will remain. We're not trying to increase it. We just simply need this approval by this commission. And Craig, I don't know if you can hand this out, but I understand, or if you want to see it, but it basically lists the conditions here. Let me got that exhibit 8. It lists the conditions and why all the conditions are met. So I appreciate your patience with that. I know it's a little longer presentation than maybe you're used to, but can I answer any questions?
Anybody have any questions of Ms. Studer?
Chairman, I do.
Mr. King?
Ms. Studer, you shed some more light on the ramifications if we were to deny the application. Are you affirming that McDonald's would have to tear down signs?
Yes.
Tomorrow?
Yeah.
Even though it's in a process of appeal? I guess that's what I'm...
No, well, let me be more detailed. We already asked this same judge to say, okay, we understand your decision, we disagree, we're going to appeal your decision, and in the meantime, Judge, will you make it so that we don't have to enforce it? We don't have to change our sign until we get the decision, until, it gets on appeal, because normally judgments aren't final until you get through the appeal process, but there's bonding, things like that. We offered to post a bond, anything so that we didn't have to go through this process. it was denied. So that is why our choices after this evening are to appeal this commission's decision if you were, not to grant this to us. I don't know that that's going to forestall us having to tear down the sign, but otherwise we are in contempt of the court. So we literally have to start the process of bringing down those signs.
And is the sign that we're talking about, the big M behind, in the drive-through lane there, that one?
Yes, the golden arches on I-25 that brings folks in from out of town, that's what we're talking about. We're not talking about one of the smaller signs.
Mr. Chairman, I just want to take a quick minute to enter Ms. Studer's information as Exhibit H. Thank you.
Oh, thank you. Sorry. I had put 8 because that was part of my submission. That was the next number.
Mr. Chairman, if I could ask another question. Is there other signs on the property that are smaller that you guys could remove temporarily that would allow you to meet the judge's 300 square feet?
No, that is my understanding. I mean, they went through a detailed analysis of trying to figure out, well, what else could we take off that's not going to create traffic problems or have people hit, their own signs or those types of things. So that's the one that would actually have to come down and be replaced with a much smaller sign.
So how many square feet is that sign currently?
Oh, boy, Mr. Waterbury, I wish I had that information for you. I might be able to find out. Oh, that one is over 300 square feet. Oh, okay. Well, that's why then. That's the sign that's got to come down.
I'm just wondering if.
It's crazy. This is.
Yeah, it is. Yeah. Maybe that sign could be replaced with a smaller sign in the same manner and still meet those requirements.
Not, I can tell you this, and I can have this confirmed, but those golden arches are not the biggest. They're already sort of reduced because of, how it's set up and that type of thing. So I frankly don't know what a smaller sign is going to look like in order to comport with the judge's decision. That, as I said, we respectfully disagree. In the event that we were successful on this appeal, the current one would go back up. And Mr. Poston, who is the franchisee, I mean, there are other hardships that he was telling me about firsthand. And there is a real impact economically as a result of having to take down this large sign. I mean, this isn't, based on his experience, this is not hypothetical. This is based on real facts.
Mr. Chairman, I have a question. Ms. Studer, could you address a statement, and I don't know if you've seen this or not, I'm going to assume that you have, that was prepared by Ryan Ford, who was represents Casco. And in the first page, I don't know if you have access to it or not. This is what I'm looking at. Well, what he says here is Casco is concerned about. Let me back up. Casco does not directly object to the relief as sought by McDonald's in its exception variance application. However, Casco is concerned about what lasting and or indirect implications the granting of a variance may have on its future rights to install off-premises signage on Lot 5. I'd be interested in your opinion on that comment, that statement.
I'm not the litigation attorney, just so you know. As I understand it, that's why we were able to get this, is because they recognize this does not impact them. If they choose to apply for 300 square feet of off-site signage on McDonald's property, we will submit the application for them. And that's why we are simply saying, that's why we need, for the moment, this exception. We asked them, and that's part of the exhibits, Casco, and this is Mark, I'm going to get his name, Kister. Anyway, I asked him, do you have plans for a sign? So we could alert 120, we're never going to use it. We have no plans to use it. We are stuck at the 420, but that's what we want to be stuck at during this appeal. We are unaware of Casco having any plans. I will tell you, we would also submit and agree to, and this is one of the conditions I spoke to Craig and Trentath about, is that if you were to approve 300 square feet for Casco, we would then reduce. I mean, so we'll live by the judge's decision, we'll live by your decision. If you decide Casco would have an off-site sign, you can see the 32 square foot sign. That's why we don't believe they're ever going to use the 300 square foot sign. It's direct people to additional parking in the back of the lot. That is why we believe, that this exception should be granted, because it doesn't impact Casco at all. They still have every right to come to this commission and ask for a special use permit to construct up to a 300 square foot sign. And we're happy at that point in time, if you were to grant that, by the way, it does violate the current municipal code for an off-site sign to be that large, just to point that out. But if you were to grant that, then we have no problem saying, okay, yeah, now because this commission went that route, we are going to have to reduce our sign. There's no way around that.
Mr. Chairman, could I follow up with a question to staff on that?
Please do.
I'd ask either Mr. Collins and/or Mr. Trembath to address the argument that we've just been presented with, see what staff's position would be on that.
Mr. Chairman and Mr. King, that was about a 15-minute argument, so if you can be a little more specific on which piece you would like me to address, I'll be happy to do that.
I guess from a general layman standpoint, if we deny this application and indeed McDonald is required to tear the sign down, I'm not sure if that's in anybody's best interest.
Mr. Chairman and Commissioner King, it's often said that tough cases make bad law. And this is one of those sort of situations. The issue that I have as legal counsel recommending to you to grant the exception is that then we would essentially be saying that section 1712-220F does not require a physical condition of the land to be present. You heard Ms. Studer's argument on that. I'm quite comfortable with our legal analysis that if you continue reading, it talks about vary the strict application of any requirement in the title in the case of any physical condition applying to a lot or building if the strict application would deprive the owner of the reasonable use. But the problem is it says of any requirement in this title, from my perspective. So even though the definition for exception and variance are separate, as Ms. Studer correctly points out, Section F ties those two back together and says that there needs to be a physical condition that affects the land, and we don't have that here. On the other hand, like we discussed with tough cases making bad law, we tried to structure an alternative, if the commission chose to do so, that would limit the signs to a temporary application and make sure that the Casper Municipal Code is complied with in the long term. It is not how I read the code, because I don't find a physical characteristic of the land under 1712-220F. But if there's a rational basis to do it, it is certainly an option for you. Not one that I can endorse, but it is certainly an option for you.
Well, I don't have another question, but I just have a full comment that, I think puts us, all of us, in somewhat, me certainly, in an awkward position to get caught up when something's still hanging out there in the courts and hasn't been finalized in the courts, for us to adjust our policies to accommodate a potential court decision, pending court decision, and pending appeal of that court decision. That's a rock and a hard place issue. So I'm not.
No, and I respect that, and I understand that, but that comes back to the unique circumstance here where we're really not asking you to adjust the code or to allow us to build in excess of 600 square foot of signage on that lot. And so while we're saying, please give us this on the one hand, we're saying, and here, you can take it back on the other, it will just give us the time we need. And I recognize it's sort of a creative approach, but I do think it is one within your authority, given your ability to vary the terms of the request, the petition, for an exception. And I respect, though, that it's a tough decision. That's why you get paid the big bucks, right? No, I'm not trying to be facetious, but I mean, this is one that I recognize is unusual.
I have a question, Mr. Chairman. The sign that we're talking about that you're going to have to take down is an off-premise sign, is that correct?
No, this
Is
is,
is it the one that I'm looking at right here in the picture? The big McDonald's.
The big golden arches?
this is not a great picture in that that's what's
There we
visible
are.
to I-25.
Okay,
That's the sign bringing folks in off the interstate. That's the one that has come down because it is 300 square feet already.
and the signs on the side of the building that say McDonald's, those are included in that 300 square feet?
Well, we only have 122 or 120.55 of other signage that to get us to the 420.
Uh-huh.
So that's why every other
Oh,
sign
every other
in
sign,
total
okay.
is 120. So the only way to comply currently with the judge's decision
Is to take down the McDonald's sign.
Are there any other questions from Ms. Studer?
Thank you.
Thank you. As required by state law, we have to invite people to comment in favor of or in opposition to all public hearings. Is there anyone in the audience wishing to speak in favor of this case?
My name is Tim Postal. I live at 2727 Hogan Drive here in Casper. Gosh, I'm a little nervous here. Never done this before, sorry. I own the McDonald's. I own all three McDonald's here in Casper. And, I don't understand all the legal stuff and what's going on. All I know is that that 5 years ago we built this beautiful restaurant, and with it we employ, I have 39 people who work there, and it helps support our organization. And I guess what I want to speak to the importance of that sign. We talk about, I get these 4 conditions and whatnot of why we should be granted this exception and whatnot, or whatever it's called. I get lost in the legal, okay? I sell hamburgers, all right? But, I have personal experience with losing a sign. Those of you who are familiar with Casper probably remembered when I lost a sign on the west side to the wind. Y'all remember that when it actually made national news. When the wind, 82-mile-an-hour wind, blew that sign down, and it landed in the middle of Wyoming Boulevard at 11:50 a.m. Didn't hit anybody. That's a miracle. So for 5 months, while we tried to figure out why the sign fell and how to prevent it in the future and how to replace it, whose responsibility and whatnot, we found out that it was a faulty weld in production. Anyways, we were able to put the sign back up, but during those 5 months, I suffered pretty good sales hit. In the neighborhood, I was looking at it last night, kind of reviewing, and it was in the neighborhood of about a 12 to 15% sales drop. That's a sign that's on kind of a community sign. This is a freeway sign. That sign is sole purpose. The only reason that sign exists, it's not for us here in Casper, because y'all know where my McDonald's is. You know where it is. You know how to find it. You know how to get there. The people on the freeway, they don't. They have no idea. And so they're buzzing through our town, and they're heading to places other than Casper, and that sign is designed to pull them off that freeway stop by and have some lunch, see our community, maybe even spend some time here, I don't know. But that's its sole purpose. So when we put that sign up, I was involved in the construction, and as we looked at where to put that sign, where the placement, the drawings have suggestions, but they don't know how the lot is set up. So we spent some time, we hired a crane, we painted a piece of plywood red, and we hung it up at different heights and such, placed it at different places on the site. And where we really wanted to be was more towards the front, because I have better visibility there. I can get the height enough to get over the buildings so you can see it as you come into town from southbound I-25. You can see it, and you can also see it coming the other direction. Because you notice, if you drive I-25, you don't see that sign until you're right on it, and you have one chance. You have Poplar, and you can exit there, and you can see it. You're actually looking at the building as you go by. You don't see it at Center Street. Even when you come up to the top of the overpass, you don't see it because the pine trees block it. They're in front of the hotel there, okay? So we wanted to pull it out. Well, we couldn't because those power lines, you can see the power lines going overhead there. We have to have, I believe it's 30 feet from those power lines from the sign. So we had to push it way back in the back of the building. And with that side, I kind of miss, like I say, the northbound traffic on I-25, but I still catch, and if you drive up the top of the hill and you come down I-25, you'll see it. It just peeks over, just the arches. You can't see the red, but you see the arches, okay? And that's enough, and to pull people off the freeway. And that allows us to, run our business. I look at tax tables all the time, and I see what sales tax is in our community because it's a good indicator of our economy. And I see the sales tax that we pull in from travelers. It's like 11% of our total sales tax take. And hopefully that restaurant is part of that. That's who pulls that in. That helps us all do the things that we want to do in our community to make our community better. Helps y'all to build roads and parks and fund the fire department, the police department, those sorts of things. Helps me to do helps me to do the things that are near and dear to my heart, like the Boys and Girls Club, like Mercer Family Services, like the soccer teams, the baseball teams, and so on and so on. I'm very, very passionate about my business. I think, as a business owner, one of my controlling values is that I use my business, I leverage my business to make my community better. And I do that by building sales and by running great operations and with the thanks of my people. Gosh, I'm getting so emotional. I don't know why. I'm so sorry. So anyways, I'm missing some stuff that I wanted to say that's important for y'all to hear. Do you have questions for me?
Any questions for Mr. Poston?
It's really difficult for me to understand how well, I don't own the property. I own that sign. I have to buy that sign. That's part of our partnership with McDonald's. So I'll tell you a little more story about that sign. For me as an operator, I'd like to buy a smaller sign because those things are pricey. They are really expensive. That's why we wanted to move it out front, because I could have maybe gotten by with a smaller sign, but nobody could see it. So, that's the optimal size. That's the right size for that restaurant. But yeah, I own that sign. So when we tear that sign down tomorrow, I still own that sign. And we put the new one up, I have to buy a new one. And I asked Vicki, I said, so what do I do with the old sign? She says, you own it, whatever you want to do. I don't know. That's tough. That's tough. They're, I don't know, $35,000 or so. It's a lot of money. It's a lot of money to put in my garage.
A lot of hamburgers.
What's that?
A lot of hamburgers.
It's a lot of hamburgers. It is.
Mr. King?
When you constructed this McDonald's and the sign that we're looking at now was initially installed, was everybody concerned under the impression that it was built to code or met all the sign coding and requirements of
Yes, you know, because again, I was involved in the construction. I mean, I got to dig the first shovel of dirt, which is kind of cool. But, and I think Judy mentioned that, is that we're in compliance of what the code says. It's all these, what do you call them? Help me here. These shared access points on that lot. You know, we share a lot of the easements. That's the word I'm looking for. Is the easements on that lot, and it's been troublesome for me as a business owner because I've had to put things on hold. You know, these easements. I mean, the gentleman we share the easements with, he wanted us to move our corral, our dumpster area. Well, in order to do that, put it where he wanted to, we had to move the power transformer. Well, the power transformer, it's not like picking up this green box and putting it over here. You have to replace the cable going to it. Okay, and I don't know if y'all experienced that, but that cable, just that cable is like, I want to say I think it was $18,000 for that store, because I had to pay for that. But it goes from the green box to the building, and it's a piece of copper like this with a casing around it, and it's very expensive, and you can't splice it, and you have to, you know. So to move that dumpster sounds like a simple thing, but that dumpster has a storage shed on it. That storage shed is $18,000, which I pay for, and so you got to move all that over. And I was running the numbers through my head, and I thought that's $100,000 to move that thing, and why? I'm trying to think of what the purpose of that was. I don't understand. Just like taking that sign down. I don't understand. If you go past that store, when you leave tonight, go past the store, and you'll see, maybe you'll see it over the freeway as you go out in the lot out here. Maybe. But you'll see that it's dimly lit. Okay, and that's an embarrassment to me, actually. I saw we had some lights go out on it, and I called Casey, Nick Sign. I called Casey over at Nick Sign, and I says, Casey, I've got some lights out. Give me a bid on what it would take to put LEDs in there. Because I save some energy, I get better lighting, and I get a longer life, right? Okay. So he gave me a price. It was about $8,500. And I says, you know, let's just do it. To rebulb the thing was about $2,500. So I've got $2,500, $8,500, but I get LED, I get some life, I get a better, the payback, and, you know, we're looking at ROI and how much more efficient LEDs are. So I says, let's just do it. $8,500, let's do it. Great. So he ordered the lights came in, and then this hit. And I says, Vicki, are we going to tear that sign down? And she says, there's a chance. And so now I have, I'm the proud owner of $8,500 worth of LED lights that if I can't put them in that sign, they'll go next to that sign in my garage because I can't use them on another sign. They're very specific for that sign on the dimensions and whatnot to fit in with the arches. I guess that's the disadvantage of that iconic arch sign, is that the interior of it is very defined. And so when you start changing out lights and stuff in it, they've got to fit. You know, it's not a square box. So, you know, if that sign comes down, I'm down sales at least 15%, I'm projecting, and probably a little bit more. And I'm out $8,500, and I have to buy a new sign, and I have a $35,000 piece of wall art or something, I don't know. So that's kind of where I'm at, you know, as a business owner. And I thought we were doing the right thing when we built the store. I thought we were. I thought we were within code. I thought we did all the right things. I trust my partner, McDonald's, to do all of that, and they did. And you know, looking at the legal things, it looks like we're in code. I didn't have a problem. In fact, I asked if some McDonald's put, you know, message centers and whatnot, and I thought maybe we could do a marquee sign with a message center so that I could advertise the restaurant. And they said, no, we can't do that because we don't have the square footage. So I says, okay, so that's what we got. As mentioned earlier, you can see how little signage is on that restaurant. You know, if you're driving at 60, the posted speed limit on I-25 as you drive past that store, it's not going to grab your eye, but those arches will.
Thank you.
Thank you.
Are there any?
Mr. Chairman, I have some issues, but I guess I feel like they need to be addressed to Ms. Studer, but I don't know if it'd be appropriate to ask her back up now or to continue on with on your agenda and perhaps address it if and when a motion is made.
Maybe, we could have, if it's okay with staff and Ms. Trimby, I thought, would have Ms. Studer come up before I call for anybody in opposition to address some of these questions that Commissioner King has. Thank you.
Ms. Studer, again, I'm looking at the letter of September 13th of 2018 from Ryan Ford with Williams Porter Day Neville. And I'm looking on page 2 where he gives, I'm sorry, I didn't love my mic like I'm supposed to. I'm looking at page 2, and he makes a comment, in April of 2013, McDonald's purchased Lot 5. At the time of the purchase, McDonald's was aware of the recorded declaration and its terms and conditions. In fact, Casco offered numerous objections to McDonald's proposed development of Lot 5 and cited the declaration to support those objections. Disregarding Casco's objections, McDonald's, based upon its own testimony and not Casco's testimony, claims it has erected approximately 420 square feet of signage after applying for and obtaining a 535 signage permit. Well before the signage installation, Casco and McDonald's began a long legal dispute, which continues to this day. Now, I guess with the question that I have is, was everybody really sure that they were in compliance with all the codes when this was initially put in place based on Williams Porter Day and Neville's comments?
Yes, let me explain, because what happened is Mark Kister with Casco did not want a McDonald's next to the Quality Inn. And so you heard he wanted the dumpster moved. He was supposed to have repaved the whole parking lot for JB's, because remember, this easement predated this. He did none of that. He did nothing to improve the property that he was required to do under the terms of the party's contract. In exchange for him repaving the parking lot and doing other work, JB's gave him a signage easement. Well, the court held that the contract was void because it wasn't complied with, and so, you know, McDonald's won on that, so the contract went away, but the easement runs with the land. So they got burdened with this signage easement. Now, so when McDonald's buys the property, when I started out, I was explaining easements. Let me give you an idea. I'm an oil and gas producer, and I come to you, and you have a farm. And you're raising corn or hay on this farm. And I say, well, hey, can I have, 5-foot easement across your property? Because someday I might lay a pipeline. And you're like, well, that's a heck of a deal. You know, I got some good money out of this. I'm going to grant that to you. And then you give it to me, and then you continue to plant, and then I come, oh, now you can't touch that 5-foot swath because you gave me an easement. It's like, oh, that's not easement law. You can continue to grow corn, but if I want to come in and put a pipeline down, I put my pipeline down, you continue to grow corn. The judge in this case held, no, you can never use that 5 feet to do anything because it's an exclusive easement and you, property owner, have no right to that land. That's our dispute. So when I say when we bought the property, installed the sign, we were in compliance. And in fact, Exhibit 4 is the site plan that the City of Casper Planning Department approved. So all of those signs went in compliance with code. All of the setbacks were met, all of the dimensions were met, everything worked because, remember, Casco is only using 32 square feet. And so because there was 600 total, and we believe that if they're not using it, we can use it, we were in compliance all the way around. And so it wasn't until the judge said, no, I'm going to say Casco gets 300 and forget McDonald's. even though you're using 420, Casper's not using it, you've got to reduce yours to 300. So that's why I'm saying, yes, clearly we were in compliance at the time. It's only because of this court decision we're in this position.
Thanks, Gene.
Did that explain it? Okay, thank you.
Somewhat.
Any other questions while I'm up here? Okay.
I don't believe so until you sit down. Is there anyone else in the audience wishing to speak in favor of? Is there anyone in the audience wishing to speak? No? Okay.
I'll come up now because I don't want to go on the record as being under objection. Ryan Ford.
Ryan.
I'm an attorney with Williams, Porter, Day, and Neville here in Casper. I reside at 4445 East 23rd. I'm here to represent Casper LLC this evening. You've seen the comments that we've prepared and issued to you. We're not here either in favor or to object to it, but since we're attorneys and we are involved in over 5 years worth of litigation on this property now, we've got to make sure that we've got some facts straight there. There are a few things that were mentioned and said that I just want to shed some light on. Commissioner King, you're exactly right. When McDonald's purchased this property, it knew that the declaration was there. And that declaration provided certain rights and easements to Casco LLC. Mr. Collins, could you go to the picture that has the following in? Now, one of the rights that was granted to Casco LLC under that declaration was the right to put up signs. And Casco did that with the help of JB's and after JB's ERC properties. That's the sign you see there. That's the sign that was up the entire time that McDonald's was building this property. Now, I want to take a step back for just a second. When I'm talking about McDonald's, I'm not referring to Mr. Moss. Casco's dispute is with McDonald's Real Estate Corporation, the national company. I believe Casco, through Mr. Kister, very much so enjoys having Mr. Postle next to him. Everybody wants a thriving business next to him instead of an empty business. And on a personal note, I frequent Mr. Postle's businesses on a very regular basis. And so I don't want anything to happen to those delicious hamburgers that I'm getting fed through the window. I appreciate what he brings to the community. I appreciate his community activities, the philanthropy that he provides, and the jobs and the services that he provides to this community. Casco's dispute is not with Mr. Postle, the franchise owner. It's with McDonald's Real Estate Corporation. Now, when McDonald's Real Estate Corporation started putting up this building, Casco said, hold on. We've got this declaration out here. I've got certain rights on this property that you're building on. McDonald's said, okay, what are you talking about? We ran them through the list of things. McDonald's took that entire declaration and they threw it in the garbage. They said, this is invalid. So that's where the lawsuit started. McDonald's didn't just say, you've got easements there and we'll let you use it when you're ready to. McDonald's said this entire thing is invalid. Threw it away. Now that's been overturned by 2 federal courts in this particular case. Now Ms. Studer was up here and she referenced exclusive easements versus general easements. She says that McDonald's Real Estate Corporation believes that it's a general easement, meaning as soon as Casco LLC is ready to use that signage, it'll comply, it'll reduce signs and let Casco use it. That's not the truth either, because back in 2013, Casco LLC spent considerable time and money developing a sign plan that it wanted to go up. It presented that plan to McDonald's Real Estate Corporation, and again, they said, no, that entire declaration is invalid. Now, 5 years later, the declaration still has teeth. It hasn't been completely overturned. It hasn't been torn apart. Certain items have been removed from that declaration, but generally the declaration remains and it survives. McDonald's is not required to tear down this sign. McDonald's has actually made representations to 2 federal courts that it's prepared to reduce the signage. Certainly that doesn't happen overnight. We recognize that. But but McDonald's has, on appeal, asked two separate federal courts to hold off on enforcing that judgment. Both of those courts have said that McDonald's does not have a good likelihood of success on its appeals. So from Casco's perspective, granting this variance, it might help, it might not. I don't think additional time is what these two particular parties need for each other after they've been butting heads for 5 years. But with that being said, I'm available to answer any questions that you might have. Appreciate your time. Again, Casco does not favor or reject this application.
I have a question, Mr. Chairman.
Commissioner.
Thank you, Mr. Ford, for your perspective on it. If this Planning and Zoning Commission, and I'm not saying it will or won't, because we're not, obviously I'm not in a position, if it were to push for a motion for a variance with a time limit on it, for example, do you and/or Ms. Studer have an estimate or a feel as to how much time you're looking at to get this resolved through the appeal process?
Tricky question, because that depends on what happens. I'm sorry, Mr. Chairman. Largely depends on what happens in that appeal process. I would anticipate 12 months from sometime this month, 12 months before the appeal is completed with the 10th Circuit Court of Appeals. Depending on what the 10th Circuit Court of Appeals says, there could be additional issues which come back to the Federal District Court down in Cheyenne for Judge Johnson to determine. And if that's the case, then we're probably looking at an additional 2 years after that before we have any resolution or before we're back up to the 10th Circuit again for a third time.
Okay.
Probably not a very helpful answer.
Any other questions? Concerns? Thank you, Mr. Ford. Well, there was 1 for, 1 not for or against. Is there any people who want to speak against this case? There being none. Mr. Wallace, Turbeth, you had said that you wanted to make a few comments after all the comments had been to help us.
Mr. Chairman, members of the commission, I was just going to answer any questions that you had. I think you can see that this is a fairly difficult case and not one that's typical. My recommendation is certainly based on the reading that we have had of our statute for a very long time, our ordinance for a very long time. And the options are before you now, and I'll leave it in your hands unless there's more questions.
Are there any more questions for Mr. Tremba? Mr. King, you look pensive.
Well, I have some comments, but I'm just thinking it would be appropriate to wait until we have some kind of a motion out on the table that's been seconded to bring those comments forward. I don't think it'd be appropriate to make the comments before we make the motion.
There being no others to speak for or against this case, I now declare the public hearing closed. Chair will entertain a motion to approve with conditions, deny or table case, PLN 18020 as exception. Do I have any motion?
Okay, Mr. Chairman, for discussion purposes, I would move approval of PLN 18020E with the condition that it be enforced for 1 year.
Do I have a second?
I'll second that.
Second.
Now I have a question.
Discussion.
Mr. Chairman, Mr. Trembath, is that a legitimate motion?
Mr. Chairman and Commissioner King, if I could make a recommendation, I don't see that there's any chance of this being resolved in 1 year. I think that's very generous. If you're going to move for discussion purposes to approve the exception, a temporary exception, I have a handout that I can give you with a recommended motion that will incorporate a lot of other findings and things that would help protect your record to make this temporary if you would like to see that.
I would very much like to see that. Mr.
Yes.
Chairman.
Is this the one that you,
Mr. Chairman, it's slightly different. It's in the form of a motion with
Okay.
other. And
Okay.
Mr. Chairman, with your permission, I'm going to hand one of these each to Ms. Studer and to Mr. Ford.
please?
Mr. Chairman, before I read this in more detail, could I also expand upon my views as to why I made that motion?
That would be acceptable.
Thank you, Mr. Chairman. I fully appreciate that, you know, the Planning and Zoning Commission is set up to ensure that any applications that come in front of us are first have been fully reviewed and vetted by staff and are in compliance with our codes and our comprehensive use plan. But I think at some point, common sense has to factor in there, and this is, I don't know if you folks have picked up on this, this is a unique case. It just something doesn't seem to be right that a judicial body can, I mean, they obviously have done what they're charged to do, but it seems like we're looking at a situation that's been in place, has not caused any problems that I've heard of or that I can see or imagine. And it seems like it would be counterproductive to deny this application. Now, I understand there is some dispute as to whether or not the sign would have to be torn down or not, or rebuilt, or whatever, but it seems to me that the status quo right now is acceptable and has been within what all parties have somewhat agreed that have been in compliance, and now it's not. And I see that the expenditures of funds to tear any facility down or part of the facility down and rebuild it, that there is a financial hardship that enters into it, and I think that needs to be taken into account in our decisions. So I just, I have trouble with staff's recommendation to deny the application, and it seems to be a more appropriate manner would be to let this thing ride itself out in court and not impose any burdens or restrictions or conditions on either party at this time. I can't see what would be gained by that. And I think we could still rest at night that we're in compliance with our charge as a Planning and Zoning Commission.
Thank you, Mr. Turnbull.
Mr. Chairman, just for procedural purposes, I believe we had a motion on the floor, no second. So if
No, we
it,
have a
did we have a
Was
second?
Yeah.
Okay, if there was a second, then still for procedural purposes, if
Mr. Waterbury seconded.
you need an amendment to the motion.
Okay.
Do we have
Okay.
to rescind the second before we make the amendment to the motion? So you have to draw your second back.
So I have to rescind my second?
No, you don't have to rescind the second, but we have a motion on the floor. So if we have a commissioner move to amend the motion and replace it with something different, you can vote on that, and then we'll have the proper question before the body.
Can I move to amend my original motion, or does
Yes,
somebody
you
else
can.
have to? Mr. Chairman, I move to amend the motion that I made to be as follows. I move to approve with one condition and the 5 findings the request for a temporary exception of up to an additional 120.55 more or less square feet of signage because strict compliance with Title 17 of the Municipal Code would create an undue hardship specific to the current applicant. The condition is that this temporary exception automatically terminates 2 years after its approval by the Planning and Zoning Commission.
Has everybody had a chance to read the 5 conditions, 5 findings? We have a new motion in front of this commission.
Mr. Chairman, I'm sorry to interrupt again, but are those 5 findings included as part of the motion?
5 findings are included as part of my motion that are specified in
Do I have a second?
your suggested motion.
I'll second.
Mr. Frith, second, the amended. Discussion? Any other questions on
Questions on the amendment?
the amendment?
I would like to, Mr. Chairman, make a comment. So when Mr. Ford talked about this going through the courts, he indicated that it could conceivably be done in a year, or if it goes in for another additional appeal, it would be 2 years after that. So we're talking about 3 years, give or take, that before it might be resolved. So at the end of 2 years, this would be, and if it's not done at the end of 2 years, they'd have to come back for an additional, to ask for this in again.
I think that would be one of their options as I read it.
Yeah.
Mr. Chairman, I'm sorry.
Okay.
I don't think we can run it out 10 years, you know. just-
We were talking about, he was talking about 3 years. So my question was why we were going 2 years when Mr. Ford indicated that it could quite likely go 3 years before it would be resolved.
I think probably in some of the, if you don't, I didn't mean to run with that, the 2 or 3 years is all up in the air anyway. So we have to,
Have to pick it years?
have to pick a year. It may be 4. 3 may be not a good, it may be too long. 2 may be better. We could all be,
That's fine. But we could also do 2 years or whenever it's finalized, whichever happens first.
oh,
But, okay, that's fine.
I hate to have an emotion or amended, this is my personal
Based on a
opinion.
court action, I
Well,
understand.
not only
that.
based on a court action, based on when something else is done.
That's fine.
That gets very, and I don't know what a legal word for that would, but that gets tentative. That's good too. Thank you. Okay, we have the amendment, grant temporary exception, and 5 findings. That discussion, we vote. You post it. Black screen.
With all members voting aye with the exception of Commissioner Ani, the motion passes.
Now we need to go back to the original motion, no, to the amended motion. We just voted to amend the motion.
Okay,
Now we have to vote on whether or not we agree with that amended motion.
okay. The recommended motion to approve
With the 5,
with the 5 findings, temporary exception up into, as listed on the temporary exception.
Mr. Chairman, question for our attorney. Wallace, would it be better if we actually read in those
Reasons.
findings that?
Read the 5 findings?
recommended, or can we just refer to?
We have done that before.
Mr. Chairman, I would feel more comfortable with that because it protects your record better and it at least shows that those things have been thought about and at least heard by every commissioner. And it doesn't take that long, so I would always encourage protecting your record.
Mr. Chairman, I believe that this can be done without any further amendments, but I would like to clarify my motion,
Okay,
my amended motion. And that would spell out that the the findings be that the temporary exception will not substantially impair the land use of the neighborhood or adversely affect the safety of the adjacent property because the signage as it currently exists complies with the Casper Municipal Code. And under this temporary exception, 2 years' time, long-term compliance with the Casper Municipal Code is safeguarded. The safety of the signage must meet the same code requirements as other signs in Casper, Wyoming. Number 2, the temporary exception will not conflict with the comprehensive land use plan as adopted by the commission and confirmed by the council, nor violate the purpose or intent of this ordinance because signs are allowed under the Casper Municipal Code and the comprehensive plan. This temporary exception contains a condition to safeguard compliance with the Casper Municipal Code on a long-term basis. Number 3, under the particular circumstances presented as set forth in the findings of the commission, strict compliance with the terms of the Casper Municipal Code will cause undue hardship upon the applicant because it causes the owner to expend substantial funds that may or may not be necessary depending on the results of other proceedings, litigation, and future contingencies. This temporary exception allows the proceedings to play out while still protecting the city's long-term interest in limiting signage to the amounts allowable under the Casper Municipal Code. Number 4, the applicant or predecessors in interest have not, by affirmative act or acts, caused the condition or use to exist in violation of the terms of the Casper Municipal Code because the temporary exception is only necessary because of a valid court order in ongoing litigation. And number 5, the circumstances of this case are unique for purposes of this temporary exception only, and specifically because the conditions of this temporary exception safeguard long-term compliance with the Casper Municipal Code, while also allowing litigation, other proceedings, and contingencies to work themselves out over time. We find that the hardship on the applicant is a personal hardship and may not require unique physical limitations or characteristics of the property that deny McDonald's Real Estate Company the reasonable use of its property. And again, that's a clarification of my motion, and I don't believe you need any.
I don't think we need it.
Mr. Chairman,
That's
I
right.
have a question, because a legal question. If during the 2-year span here, if the appellate court rules, let's say they rule upholding the judge's ruling, at that point then, the sign will have to come down. Is that correct?
Mr. Chairman, that is correct. Depending on how it's upheld. I mean, there are a lot of things that could happen at that appellate court level, short of just yes or no, we uphold it. They could remand it for more findings. We'll have to deal with it at that time. But the way that the motion is structured makes this exception temporary for only 2 years, and then whatever comes down, the parties are going to have to comply with the Casper Municipal Code.
Thank you. Did I answer your question, Commissioner? Any other further discussion? We have a motion. We have motion and seconded. The five findings were read in their entirety. We have a vote.
With all members voting aye, with the exception of Commissioner Ani, the motion passes.
Thank you, Commissioner. That concludes the public hearing for this evening. If there's anyone in the audience that wishes to discuss anything further, please come forward and limit your time. There appears to be none. Chair calls for communications from the commission. OID. You have none?
Pardon?
Got anything from the OID?
OID, I'm sorry. I meant to bring something on it, but I forgot to.
Communications from the Community Development Director, Liz.
Mr. Chairman, members of the commission. Tomorrow afternoon from noon to 3, we are having a walkthrough of the Plains Furniture property for interested buyers. That property has been put up for sale with an RFP. 160 days will make it due in mid-February. If any of you have not yet gone through that property and would like to walk through, it has been completely gutted, and Craig will be one of the tour guides, and then we'll also be looking at the livery stable. So if there's interest by this body, again, 12 to 3 tomorrow, we'd be happy to have you there. And then thank you for attending the training yesterday, and I know Dee's got the next one down for October on the calendar for all of us. So that's it.
Thank you. And anything from council, Mr. Hopkins?
Not much. Thank you, Mr. Chairman. I would like to thank you for moving forward with the state office building replat, rezone. As you're fully aware, it's a $40 million project, and it's a huge piece to make OYD go forward and build Central Casper. Just thank you for that.
Thank you.
Question for me?
Yes.
Shoot.
Oh, yes.
Mr. Chairman?
Yeah, please, Mr. King, I understand.
Councilman Hopkins, I've got a
Bone to pick?
no, it's not a bone. Back in June of last year, 2017, Planning and Zoning was asked to vote on proposed changes to the parking ordinances, specifically related to parkways. And we denied those changes. And we were also asked to give an opinion, or I don't know, I can't recall if we were asked or if we just wanted to give our opinion as to what we thought should happen with the parkways. And our unanimous position at that time was that the city not allow parking on the parkways. And I'm just wondering, is city council addressing that or going to address it, or is it kind of?
As far as I know, Commissioner King, the issue has not really come up again.
I suspected that.
I understand it's a problem, especially if you have people parking in your parkway in front of your house. And quite honestly, I think sometimes it begins to look like a junkyard in some streets, but it hasn't come up to council again.
Do you foresee it coming up, or is somebody going to have to bring it up from the outside?
Right now, we got our hands full with some of the things going on, but I don't know that it's on our agenda.
Okay.
It hasn't been docketed as far as I know.
Well, I remember at the time that the discussion was that it was going to be deferred until after the parking study was completed, which really didn't relate to that issue, but that was the reason for postponing any action. And now that the parking study is out there and can no longer be used as a
And quite honestly,
use for
the parking
punting,
study really didn't address that specific issue as I recall. So,
well, it didn't, and it wasn't intended to, but that was one of the reasons that it was not acted on at the time. And I'm thinking about, I think it was.
as far as I know, it's not on the agenda, and it hasn't come up again.
Okay.
I know that's not, that's where it stands.
Or maybe it should come up again.
I'm sorry?
Maybe it should come up again.
Can we make a motion on that?
Well, yeah, I think it would be, again, just from a personal standpoint, I'd be curious to know what city council, and maybe wait till the new members get on the council, but I think that that's an issue that is still a thorn in some people's sides out there, and I think at some point in time, when all the other issues are laid to rest, which will never happen. But
What I might suggest, Commissioner, is that, and Mr. Chairman, as you might have noticed, we have changed the format a little bit on council meetings. We now have the public comment section a little earlier in the meeting for those people who don't want to stay until 9 or 10 o'clock at night.
Yeah.
And that might be at your pleasure. It could certainly come up there.
Well, maybe I'll get Dennis Deansland to bring it up so that
Okay.
stay in the shadows. But anyway, I'm just curious, because I hadn't seen any action on it, and I didn't know if there had been any discussion or not. So that's all I had, Mr. Chairman.
Commissioner? Excuse me, Chairman. Yeah, I guess piggybacking off that question, I would wonder, as far as the enforcement of parking on the parkways, I mean, it is a violation of municipal code and why those violations have been left to exist.
Well, I really can't tell you I can't tell the police department how to enforce codes. I mean, it depends on how tight you want to do something.
Dallas does, why can't you?
I'm not the cops. So, I think we do have some things that happen. Matter of fact, we had one this last week or so. We had a construction project that got a few complaints on, and quite honestly, within 24 hours, they were solved. Trash, some drainage issues, and so certain things do happen, but they don't always happen in the time we'd like to have it happen. But that was one example when we had something happen very quick.
Well, I would back that up with, I've had some personal experiences recently with code enforcement, and the city has been extremely cooperative with the issues that I was concerned about. So I know that they're on, if the issue's out there and they're aware of it, they'll address it. So that's, I would second that comment.
Okay. Thank you.
Thank you, Mr. Hopkins. Any other communications for this commission this evening? There being no further business to conduct, Chair will entertain a motion to adjourn this meeting.
Mr. Chairman,
Yes?
I would
Commissioner.
move to adjourn the meeting.
Mr. Frank.
Second.
Mr. Waterbury, thank you very much. Please cast your vote.
Mr. Chairman, if you trust me, everybody voted yes.
Oh, we trust you.
Oh, no, I'm sure we wanted to stay till noon.
On this signage deal, how does that end up in federal court? I mean, why is that not a state court issue?
Easements suck.
Oh, hey.
Never have